Well, good afternoon. Welcome to Standpoint's April webinar. My name is Ty Sinavan. I'm the Director of Organizational and Staff Development here at Standpoint. A little bit about our organization. So Standpoint provides legal advocacy and legal advice to survivors, advocates, and other professionals. We serve the entire state of Minnesota. In our organization, we have a team of attorneys and advocates, and our main goal is to assist individuals who have experienced domestic violence, sexual violence, and trafficking when it includes domestic or sexual violence. We also provide assistance to system professionals who interact with survivors. We do trainings, we answer calls to our action line, and we are here to assist, so please call us when you need to. For today's topic, it is Title IX in 2020, and presenting is Tracy Thomas Card, who is our Advocate Support and Grants Manager. My role today is going to be helping her with facilitating questions that you have during the webinar. So please go ahead and type your questions in the question tab, and I will give them to Tracy. And we have already uploaded into the chat box the link to our Dropbox that has a PowerPoint and the other materials. So Tracy will be referencing them today in her presentation. Also, I want to quick remind everybody that we are recording this today, and I will be uploading it to our YouTube channel later. Go ahead, Tracy.
All right, thanks, Ty. So as Ty said, my name is Tracy Thomas Card. I'm the Advocate Support and Grant Manager at Standpoint. I've been in domestic and sexual violence since 2004, doing both direct services as well as prevention work. And my area of specialty, as you might have guessed from our topic of the webinar today, is Title IX. So today we will be talking about a number of different things. I'd like to first start by telling you a little bit more about Standpoint and what we do. Ty, if you want to go to the next slide. All right, so as Ty mentioned, we have been around since 1996. We were formerly known as the Battered Women's Legal Advocacy Project. Currently on our staff, we have 5 attorneys and 7 advocates. And as you can see, all of our attorneys and advocates specialize in different areas. So we provide services statewide, and our services are free and confidential, regardless of income, and there is no intake required. So Ty, if you want to go to our agenda. All right, so the agenda that we'll be covering today, we're going to cover a few different topics. Minnesota 135.15, which is the sexual harassment and violence statute. Title IX, we'll be talking about the newly approved Title IX regulations, and then we'll talk advocacy strategies during COVID-19. And next. All right, so let's start by just talking briefly about Minnesota 135.15. That's the statute number. So who does this statute apply to? It's important to know that this statute applies only to higher education institutions. It does not apply at the pre-K-12 level. And so this statute applies to all institutions that are governed by the Board of Trustees at the Minnesota State Colleges and Universities system. It applies to private post-secondary institutions that offer in-person courses on a campus located in Minnesota. And it is requested that the University of Minnesota comply with this statute as well. And the only reason for that is because as the flagship institution, legislature is required to ask that they request to comply versus actually mandating that they comply. All right, and so if we go next. So there's a few things in this statute that I think are very relevant to institutions of higher education. First and foremost, it requires that institutions have a clear written policy around sexual harassment and violence. And so this policy has to apply to students and employees. It has to include the right to assistance from Crime Victims Reparations Board and the Commissioner of Public Safety. It has to include procedures for reporting incidents and disciplinary actions against violators. It has to be public. It has to inform students and employees of the policy, and each student has to receive a copy of this policy during their registration. In addition, The policy must forbid retaliation and include policies and procedures for investigating both sexual assault as well as retaliation. Okay. So the next requirement within this statute is that institutions must respect the victim's rights. So what that means is that institutions must treat victims with dignity, offer fair health care, and not suggest that they're at fault or could have acted to avoid the crime. The policies must also let victims decide what's best to do, offering them prompt assistance in notifying law enforcement if they choose, and working to protect the victim's privacy. In addition, the policy must inform victims of available advocacy services as well as free legal resources and services, and it must offer uniform amnesty for a victim or a witness for violating the institution's conduct policy on the use of drugs and alcohol. So meaning that if a victim was drinking or was using other substances, they cannot be punished for that if a sexual assault also took place. Ty, can you go to the next slide, please? Thank you. So institutions that have 100 or more students have additional requirements. And these additional requirements include that they must work with local law enforcement. They might either establish a joint sexual assault protocol team with local law enforcement, or they can enter into a memorandum of understanding with the primary local law enforcement agencies that serve their campus. The MOU needs to be updated every 2 years, distributed to employees every year, and must delineate and share protocols of investigative responsibilities. In addition, these universities are also required to have an online reporting system for complaints of sexual harassment and sexual violence for students and employees. The online reporting system can take anonymous reports, though schools are not obligated to investigate anonymous reports. The reporter must receive information on who will see and have access to the report and contact information for on and off-campus organizations that serve victims of sexual violence. These reports are considered private data for individuals. Colleges and universities with more than 100 students also are required to report their annual statistics on sexual assault to the Office of Higher Education by October 1 of each year. Then the Office of Higher Education in Minnesota will release a report. The 2019 report is available on their website if you'd like to review. This statute also requires that universities with 100 or more students must train their employees who deal with sexual assault complaints in collaboration with the BCA or another law enforcement agency with experience in criminal sexual conduct. Students who are on campus for one or more courses must also be trained. Student health service providers must screen students for incidents of sexual violence and sexual harassment, and they must offer students information on resources and procedures. In addition, schools need to designate a confidential resource person. This confidential resource person must be trained in all aspects of responding to incidents of sexual violence and sexual harassment, and must offer resources and procedures to victims. I like to clarify here that just because a school has designated somebody as a confidential resource person does not necessarily mean that they are considered confidential or to have privilege under state law. So it really is dependent on who is designated at this institution. And finally, institutions with 100 or more students have to limit access to sexual assault related data to individuals unless they have explicit authorization. All right, Ty, let's go to the next slide. So now just getting into Title IX, I always like to show people the exact language in the Title IX Education Amendment. And as you can see, it reads, "No person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. So we'll talk a little bit about the history of Title IX and how it came to be, but I do like to point out that a lot of people in more recent times have started thinking about this bill as being, or this law being specific to sexual assault. The actual words sexual assault don't appear anywhere in the language of Title IX. It was originally started and designed to address really gender-based equality. It affected female students having the ability to participate in sports teams or in STEM fields, and then has since expanded from there. All right. I also like to touch on the Clery Act, which is directly related to Title IX and is still required under the new regulations to comply. So the Clery Act originated in 1990, and it was created after a student named Jean Clery was raped and murdered in a residence hall in 1986. So up until that point in time, colleges and universities did not have a mechanism for reporting crimes that had happened on campus. And so institutions of higher education that participate in the federal student financial aid programs are subject to the requirements of the Clery Act as well as to Title IX. And essentially what this means is that each year institutions have to disclose campus crime statistics and information about campus security policies as a condition of participating in the federal student aid programs. Thanks, Ty. So we're just going to do a brief history here. So in 1970, Congress was holding the first hearings on sex discrimination in higher education. So this was before Title IX even got passed. And then 2 years after that, Title IX was enacted by Congress and signed into law by Richard Nixon. Then in 1980, the U.S. Department of Education was established, and primary oversight of Title IX was transferred to the Office for Civil Rights. Next slide, Ty. Thanks. In 2011, the Office for Civil Rights issued what was known as the Dear Colleague Letter on Sexual Violence, and this provided colleges and universities with a semblance of guidance on how to start addressing sexual assault, sexual harassment, dating violence, the forms of violence that they were seeing students experience on their campus. But it wasn't quite enough. Colleges and universities were requesting more guidance. And so in 2014, the Department of Education, the Office for Civil Rights, released what was known as the Q&A on Title IX and sexual violence. Fast forward to 2017, the new administration, led by Betsy DeVos in the Office for Civil Rights, essentially withdrew the 2011 and 2014 guidance and proposed new guidance. Ty, if you want to forward, thanks. So that new guidance, which we're going to be talking about today, was submitted for publication and underwent public review. So the public review received hundreds of thousands of comments, more than 104,000 comments. And so understandably, it took them a while to review each and every comment to determine whether or not they were going to approve the changes that were proposed. Fast forward to March 27th, 2020, the Office of Management and Budget at the White House did approve the changes proposed by the DeVos administration there, and have not yet, though, released a date as to when those regulations would be rolled out. So what does this all mean? So a big question that people are asking is, in light of the rescission of the 2011 Dear Colleague Letter and the 2014 Q&A guidance, are existing resolution agreements between OCR and schools still binding? And the answer to that is yes. So schools who entered into voluntary resolution agreements with OCR to address the deficiencies and violations that were identified during an OCR investigation based on Title IX and its implementing regulations. The existing resolution agreements remain binding upon the schools that voluntarily entered into them. Such agreements would be fact-specific and do not bind other schools. So if a school has a question about an existing resolution agreement, they should be contacting their OCR regional office. And Ty, I just want to pause to see if there's been any questions yet.
No, no questions yet. And I did give you control of my screen so that you can be able to move. Do you want to try doing that? So you
Yeah,
don't have
I did, and it's not working.
Okay.
So I'm not sure why.
Okay. It still shows it on my end, but it's not working for you now?
No,
Okay. Well,
sorry.
I'll keep moving it for you. I just didn't want you to have to keep saying next slide.
Thank you. Yeah, it's a little awkward, but we're getting through it. All right, so what does this mean for schools and universities right now? It means that until these rules are officially released, they should be complying with the guidance that the schools currently have in place. But as advocates, you want to start preparing your staff and your volunteers that there is going to be new information forthcoming. So when you're working with clients in a school-based setting around Title IX, you want to always look at the school's policies, which should be publicly available again. They're usually on their website. With K-12, it tends to be a little bit trickier. And actually some of the new regulations are proposing that K-12 have to make their policies more clear and not just lump them in as they often are now under anti-bullying policies. So look to the policies that the school has already, and then start now by prepping your staff and volunteers that very likely could even be as early as fall. Policies at schools in the district may start to change. It's also really important for advocates to reach out to the schools in their areas to know who the Title IX coordinators are. So if you're in an area that has a lot of colleges and universities, or a bigger college and university, sometimes they have multiple investigators taking reports, while smaller schools may only have one person doing that job in addition to other jobs. And then at the pre-K-12 level, the entire district might be assigned one Title IX coordinator, but should have somebody at each school that students and staff can report to. It's also a good idea to know what counseling services and other support services are available at the school. And I always recommend to advocates that they have a list of both school and external resources, just in case clients aren't comfortable with one or the other. All right, Ty, we'll go to the next one. Thanks. So some of the changes are that schools' responsibilities to investigate would be limited to, and I quote, formal complaints or alleged incidents that happen on campus or within an educational program or activity. So right now, it's unclear if the new guidance will allow schools to investigate situations that happen, say, in an off-campus apartment, for instance, which right now, schools are required to investigate those sorts of situations so long as they involve two parties who are enrolled at or work at the school. But it's unclear right now if the new guidance will allow schools to do that. And next. Another change is the implementation of mediation and other informal resolution procedures. So this was actually a regulation that was rolled back in the Obama administration. They highly discouraged informal mediation and resolution processes when it came to sexual assault cases. However, the new regulations are recommending that schools implement that. And specifically what the regulations say is that if all parties voluntarily agree to participate in the informal resolution, it won't involve a full investigation and adjudication. It essentially says that the school may facilitate an informal resolution to assist the parties in reaching a voluntary resolution. It is not clear yet who the mediator should be. And then next. Another big change is the time frame for investigations. So in the Obama administration guidance that gave pretty specific timeframes for when an investigation should be completed. The new guidance has no fixed time frame under which a school must complete a Title IX investigation. It simply says OCR will evaluate a school's good faith effort to conduct a fair, impartial investigation in a timely manner designed to provide all parties with resolution. Next. So another change is the prohibition of a single investigator model. So the new guidance instead requires a decision maker separate from the Title IX coordinator or investigator. It hasn't been made clear yet on what that is supposed to look like. But I do think it's important to emphasize that no matter what happens, and this happens based on the current guidance as well as based on the new regulations, that whoever is investigating incidents of sexual assault or sexual harassment on campus may also have a role that is primarily about investigating other misconduct issues. So they may not necessarily have adequate training to conduct a trauma-informed investigation. Sometimes they're investigating things like plagiarism or cheating or underage drinking. So understanding how you as advocates can help support the victims that you're working with through these investigations, preparing them similarly as you would prepare them for maybe a law enforcement report, understanding that Title IX investigators, law enforcement, they all have different goals in these investigations, and that they're not necessarily there for the victim, so to speak. They're there to figure out what was happening.
It is a
Next.
question, Tracy.
Sure.
Will the changes require informal resolution policies be specifically outlined or just broadly stated?
My guess is that they would require that the policies be specifically outlined in the school's policy. But again, the guidance that's been released did not make that clear how they wanted that to work. So who the mediators would be, when they would offer that to students. So we're still waiting for some Q&As to come out about that. Were there any other questions, Ty?
No, thank you.
Yeah, you're welcome. So then another change is what's known as the live hearing requirement. So there's nothing in the new guidance that talks about needing live hearings in the pre-K-12 environment, but it does make it very specific that live hearing requirements need to happen in the higher education context. Now, we'll talk a little bit about this later, but live hearings does not mean that people have to be in the same room with one another. It just simply means that they can be done over a virtual platform, right? And then we'll go next. Okay, another change, and this is probably one of the bigger changes, is the rights of the parties involved or their advisors to cross-examine each other. And so specifically the guidance says the opportunity to test the credibility of parties and witnesses through cross-examination must be made available. As you can imagine, this is causing victims and advocates quite a bit of concern because victims have already gone through a significant amount of trauma and experiencing the violence already, and to then be subject to cross-examination, similar as to what you would in a courtroom, can create a lot of additional trauma. So it's really important for advocates to prepare the clients that they're working with who choose to go through with Title IX investigations that they may eventually be cross-examined. And it might be by the person that caused them harm, or it might be by that person's advisor. So it could be an attorney, could be another support person. Another change is that the standard of evidence is left up to the institution. So prior to this, the standard of evidence in Title IX investigations had been preponderance of evidence, which simply means that it's more likely than not that the incident occurred. However, at this point, the new regulations are leaving it up to the institution whether they use preponderance of evidence or clear and convincing. And specifically, the guidance says that the investigators or separate decision makers with or without hearings must make findings of fact and conclusion as to whether the facts support a finding of responsibility for violation of the school's sexual misconduct policy. If the complaint is presented if the complaint presented more than a single allegation of misconduct, decisions must be reached separately for each allegation. And the findings of fact and conclusions need to be reached by applying either the preponderance of evidence standard or the clear and convincing evidence standard. So when colleges and universities roll out their new guidance, they'll need to make it clear which standard of evidence they are using.
There's a question, Tracy.
Sure.
Is the institution being defined as individual institutions, or does one system policy constitute an overall institution?
Yeah, so it's going to depend on the school. So for instance, MnSCU state systems, the colleges and universities within Minnesota state and college system, they would likely be under one system policy, similar to what I would imagine the University of Minnesota system. However, if you're a private institution, you wouldn't necessarily be under a blanket policy that other institutions are under. And same with K-12, I imagine it would go by the district level, but again, the guidance is pretty unclear yet about how K-12 institutions are doing this.
Thank you,
Thanks, Ty.
Tracy.
Yep, thank you. Oh, I forgot to add a title here. I'm sorry. And sorry, another change of this is change in the new regulations are the findings of responsibility. And so specifically, the guidance says that where there has been a finding of responsibility, the proposed regulations would require remedies that are designed to restore or preserve access to the school's education program or activity. And then goes on to say that disciplinary sanction decisions have to be made for the purpose of deciding how best to enforce the school's code of conduct, while also considering the impact of separating a student from their education. Any disciplinary decision must be made as a proportionate response to the violation. So essentially what I take this to mean is that while old guidance made it very clear that interim suspensions, suspensions themselves, and then expulsions were good sanctions to have in sexual assault investigations, the new guidance is really encouraging schools to think about how they can sanction students while also preserving their right to an education. The other change is the appeals process. So if a school chooses to allow appeals from the decisions regarding responsibility and/or disciplinary sanctions, the schools can choose to allow an appeal, 1, solely by the responding party, or 2, by both parties, in which case any appeals procedure must be equally available to both parties. But the big change here is that it gives schools the option to decide if it's just the responding party that gets to appeal or if it's both parties in the case that get to appeal. All right, so a couple questions to think about as we are experiencing COVID-19 and how to continue to do great advocacy work with clients that you may not be able to see in person. So the first thing that I want to talk about is do these questions and answers apply to both pre-K-12 and higher education? And the following questions and strategies all apply to both. So the first question I've been getting is, do schools have to resolve investigations that were ongoing before the pandemic? The answer to the question is yes. So just because campuses have closed and schools have closed across the nation does not mean that schools are then rid of their obligations to investigate anything that was ongoing prior to that. It may look a little different now and it may take a little bit longer, but they still have to, at least at this point in time, they still have to complete investigations in a timely manner. Do schools have to take new complaints that might happen during the pandemic? And the answer to this is also yes. So just again, just because the campuses are closed and the schools are closed does not mean that students are not also still experiencing violence. In fact, I could see, particularly as schools are moving to virtual platforms, an uptick in online sexual harassment and online stalking, all of which schools are required to investigate under both Clery and Title IX. Sorry, Ty, I'm just going to take a quick break to take a drink of water here. Okay, so another question that I get is, do online or telephone hearings put students or staff at a disadvantage? The answer to this is no, and I want to talk about why that is. So for a long time, people were making the argument that it's so much better to have in-person hearings because then you can read nonverbal clues, you can look at body language, you can look at eye contact. But the reality is we really don't want investigators or decision makers basing their decisions of responsibility off of the nonverbal clues a person may be giving. One, it's not considered evidence-based in any way, shape, or form. And two, online or telephone hearings actually have quite a few advantages for both parties involved, in my opinion. It allows them to still comply with the new regulations in terms of having the live hearings, but it forces a separation between the victim in the case and the accused in the case. So there's actually quite a bit of benefits to holding online or telephone hearings. I know some schools are also looking at how to do televised hearings, similar to what they might do at a courthouse. So what can advocates do currently? So I think there's a lot, right? Advocates can still be a support person throughout the Title IX process. And that means you could be present in quotes. So however that works for you and your client, could be present at the initial report, at investigative meetings that might happen. They can be present during hearings via a conference call or a virtual meeting platform. And remembering that while advocates are the support folks, or generally are support folks for the victims, the accused students also have the right to have advisors or support people with them. Some schools may limit that to one person, in which case you might be deciding with your client, is that you as the advocate? Does your client need an attorney? I would recommend, if the accused student has an attorney for their support person or their advisor in a Title IX investigation, that you also seek to find legal resources for your clients, simply because the new regulations are going to allow the parties or their advisors to do the cross-examinations. And so you want to make sure that your clients are as prepared as possible for those things. You can provide referrals to attorneys if needed. And so sometimes we get questions as to why clients would need attorneys in Title IX. So remember that Title IX is just one of the remedies that students and staff have available to them if they've experienced sexual violence or sexual harassment at their school. They might also want to look into pursuing civil remedies or pursuing criminal proceedings, reporting to law enforcement and going through the criminal justice system. And so if that's the case, there are multiple reasons why an attorney might be needed. Additionally, advocates can continue to request academic accommodations. So that might be things like class section switches or assignment extensions or other sorts of accommodations that would be designed to help your client succeed academically while they're undergoing this investigation. And folks might be asking themselves, what sort of accommodations can we make given that our students are all online now? Or in K-12, maybe they're not having classes right now. But we need to think too, are there clients who are in online classes with the person that harmed them? If so, that's very reasonable for an advocate and the client to make that request to switch sections. So still thinking creatively about ways that you can request academic accommodations. With housing or financial accommodations, so one of the things to think about is if you're working with, say, a college or university student, most of the universities and colleges in Minnesota have closed their campuses, but they also have to keep some parts of their residence halls open, specifically for international students, for students who are homeless, or for students who don't have a safe place to live elsewhere. And so in terms of working with students through a Title IX investigation, checking with them to make sure that the person that harmed them isn't also still on campus. Thinking about whether or not the student needs a partial or full refund of tuition based on what has happened to them. So this is the sort of accommodation that usually comes at the end of an investigation. And generally it's dependent on the schools, whether or not they will grant these requests. I've seen better luck at some schools than others in terms of requesting financial aid accommodations. And again, with COVID right now, a lot of schools anyways are looking to partially refund students' service fees, partially refund student tuition rates. It's just really going to kind of depend on the school. So reaching out to the financial aid office is sometimes a good strategy to see what's available to students who have experienced violence. And then, of course, continuing to provide referrals to trauma-informed counselors or therapists. Again, maintaining that list of both school-based resources as well as external resources, and particularly right now, looking for folks who are specializing in telehealth services is important. All right, so I want to talk through some of the Minnesota-based as well as the national resources that advocates can take advantage of when they are looking to find out more about Title IX investigations, about Minnesota 135A15, and about some of the other remedies that are available to participants. So first and foremost, I want to offer Standpoint as a resource. As you all know, we have advocates and attorneys here who specialize in varying areas of the law and safety planning, technology safety. We've taken quite a few calls in recent years around technology abuse and how victim survivors are experiencing stalking and harassment using various forms of technology. And so we're very happy to work with you to help safety plan for your clients, to answer any questions that you have. And again, all of our services are free and confidential. And we're here for victims, for advocates, for attorneys, and for other professionals who are working with people who have experienced sexual and domestic violence. The second resource I want to talk about is actually a civil remedy that clients who've experienced sexual harassment and sexual violence within the school system have available to them, and that's a remedy through the Minnesota Department of Human Rights. So there is an option for folks to file a complaint through MDHR. It will be investigated by a neutral fact finder and a determination of whether or not the institution failed in their responsibilities to keep students safe or to keep an employee safe will be determined. Out of that remedy, possible resolutions could include requiring the schools to update their policies, to add additional trainings for students, staff, and faculty. It could potentially mean monetary damages are awarded to the clients that you're working with. So it's definitely an option that's worth exploring with your clients. There is a specific time frame in which MDHR complaints have to be made. I'm not certain at this point in time with COVID if that time frame is being extended or not, but it's certainly something that we can explore with you. Another resource I want to offer out to folks is Know Your Nine. A lot of times when I have been working with victims who have been victimized in school, they're either a student or staff member. At some point in time, often I'm asked, well, how can I make sure this doesn't happen to other people? What can I do to get involved in the movement? And of course, it's going to be dependent on where your client is at in their healing process. But I always like to suggest folks go check out Know Your Nine as a resource. They've been an organization that's been heavily involved in activism and legislative efforts to ensure that students, staff, and faculty know their rights, both under previous guidance as well as the new guidance. The Office for Civil Rights is something that I have talked about pretty significantly throughout this webinar. I want to talk with folks just a little bit about the complaint process. So there's a couple of things to note about the OCR complaint process. First, I recommend that I recommend that advocates and their clients go through the school's Title IX investigation first and then file an OCR complaint, but you don't have to. If your client decides that they want to file with Title IX, they want to file with OCR, they want to file with MDHR, they want to file with law enforcement, they can do all of those things simultaneously. A while back, we were receiving quite a few comments that schools were telling clients that they either were going to put their own investigations on hold while a client went through the criminal reporting process, or vice versa, right? Where law enforcement would be trying to obtain the reports of school investigations to aid their own investigation. These are two totally separate investigative processes. The end goals are separate. And so if somebody decides they want to do all of these things simultaneously, school should not be advising them that they can't do this. Now, that being said, if you're working with a client whose school does not have a clear reporting process, maybe they don't have policies listed on their website, maybe that's a time to go directly to OCR, right? And say, I can't find any information on how to report a Title IX violation to this school. Generally, though, OCR will ask why the client has not undergone the institution's process first. And so that's why generally I would recommend that the student at least begin going through the school's process if they have one available, before determining whether or not it's right to make a complaint to OCR. Now, in making a complaint to OCR, it's a fairly user-friendly form that clients and their advocates can work to fill out. There, again, like with Minnesota Department of Human Rights, there is a time frame that students are allowed to make the complaints to OCR. If it's past those deadlines, then a waiver explaining why it's past those deadlines is required. With OCR, unlike with the Minnesota Department of Human Rights, OCR's job is to hold the schools accountable. So that means that they won't be awarding any, let's say, monetary damages necessarily to a client, but they can sanction a school pretty heavily in terms of fees and fines. And in fact, the Department of Education under DeVos has worked pretty hard to clear the backlog of cases that had been built up in the Office for Civil Rights, and have been providing resolutions that are finding schools accountable if they're not doing what they're supposed to do. So I have hope that even though some of us aren't too happy about some of the new regulations, that they will continue on in that direction of being able to clear backlogs of complaints and holding schools accountable when they're not doing what they should be doing for students. I also always like to put the Association of Title IX Administrators in my resources, ATICSA. They have a members page, but they also have access to a lot of free resources and guidance. They've been staying up to date on the proposed changes with Title IX. They've released a lot of great resources from anywhere from things like recommended policies, recommended accommodations. They have white papers available on the topics. They have, actually I was just on their site, and they have a really great FAQ about how schools should be handling Title IX complaints and other complaints of that nature during the pandemic. And they had some really good recommendations of how schools can continue to implement investigations and sanctioning during this time. So I recommend going to check that out. All right, so talked a lot. We had a lot of information that we covered, but now I want to make sure that we have time for your questions.
There aren't any questions so far?
Okay, we'll just give it a
Yeah.
couple of minutes.
Okay.
Yeah. And I should say, Ty, while we're waiting for questions, advocates that are listening should know that Standpoint will continue to monitor the newly approved regulations, and as soon as they are what's known as publicly released, we'll alert folks to that, and we'll also alert folks to any guidance that comes out clarifying some of the things that we talked about today. For instance, the mediation process and what that will look like, or the appeals process and what that will look like.
So I just saw on the question tab that it says that there's questions, and maybe I can't see them. There, from my what I have seen, there was 5 questions and 3 that I addressed on my own, and 2 that I gave to Tracy. So if there are other questions that are other than the 2 that I had Tracy answer, maybe you can try if the question and answer tab's not working, can you try typing it in the chat box and just,
Yeah, because
yeah.
I'm seeing the same thing you are, Ty, the 2 questions that you asked.
Okay. And just know if you have questions later on, you can always call our office as well, or email in info@standpointmn.org, or to Tracy directly, tracy@standpointmn.org.
Yeah, I'm not seeing any other questions, but again, if I'm missing something, go ahead and type it into the chat, folks.
Yeah, because I see stuff coming in through the chat to us, and you can chat it to everybody, or you can just chat it to the panelist as well. So whatever would work. Will this presentation be sent out so we can share with others? Yes, so when the recording is done, I will upload it into our YouTube channel. And what I can do is I can, if you, what would be easiest, Tracy, do you think? Should we just send the PowerPoint out into the listserv, or have people request it from us?
You know, I know that for this particular webinar, Ty, I know that we have some folks who are working at colleges and universities on, and if they would like to share that out with other folks at their institutions, they can certainly send an email to us, info@standpointmn.org, and I'm happy to share those resources. I also will say too, for advocates and other professionals who are on this webinar, I know a lot of schools are undergoing reviews of their conduct policies right now with anticipation of the changes. Please remember that as the schools in your area are going through these, or as your own school is going through these, to be in compliance with Minnesota 135A15 as well is going to be really critical. And again, Standpoint is happy to provide guidance around that as well.
Okay. Yeah, so apparently there must be some issue with the link. I did test out the link, and what and how I got the link to work for me was I copied what we had shared in the chat box, and then I just copied and pasted it into a new tab to get it to work. I know normally when links come up like that, it's like highlighted and underlined and you just click on the link. But for this one, somehow it didn't do that. So I actually had to copy and paste and go into a new tab to get that to work. Because we don't, someone's asking us to email, because we don't know what your email is, if you want to email us, you know, you can email the info@standpointmn.org or Tracy directly, tracy@standpointmn.org, and ask for the PowerPoint. We'll be happy to send that over, okay? There's a question, Tracy. How much time will institutions have to enforce the new policies after they're publicized?
Yeah, the age-old question, right? It's a really important question, and unfortunately, what I have to say is that the U.S. Department of Education has not released that information. I know that when the previous guidance had been issued, they did give schools a certain time frame in which to implement. So I would say start, if you're a school, start working on it now, start connecting with advocates in your community to have them help inform your policies so that they can still remain trauma informed. But at this point in time, schools aren't required to roll out the new regulations until they're publicly released. And we don't have a date set as to when that will be. Particularly, I know that there are some legislators who are pushing DeVos to hold back on the public release of the new regulations until the pandemic is over. So it may not be until that. But generally, the Department of Education will give you a time frame as to when the new policies have to be enforced. Great question.
All right, and I don't see any other questions, Tracy.
Nope, I don't either.
Okay.
All right, well, thank you so much, everyone. Again, don't hesitate to reach out to Standpoint if you need any guidance on how to work with clients who might have experienced sexual violence, sexual harassment, stalking, or dating violence at their school, remembering it applies to both students, staff, and faculty at those schools. Remembering that any new policies that schools are releasing should comply with Minnesota 135A15, as well as with the new regulations once they're publicly released. But again, thank you all so much for attending. We hope this was valuable and informative to you. And like Ty said, we will put the recording up on our YouTube channel.
Thank you.